courtroom holds its breath, and a prisoner hears, "Dad." A black man sits in an orange jumpsuit in a wood-paneled courtroom in Beaumont, Georgia. His wrists are shackled. The chain rests on a table scarred by decades of desperate fingernails. A fluorescent tube overhead hums, faint, constant, the sound of a building that has stopped caring about itself. The defense attorney, white, mid-30s, tailored charcoal suit, rises and addresses the man in shackles. He calls him Dad. The judge, white, mid-30s, black robe pressed to the collar, sets down her pen. She calls him Dad, too. This man raised them when the world threw them away. Then the world threw him away. If you believe the people who build families deserve to be fought for, stay. This story earns every second. But to understand that silence, we need to go back 28 years, to a screen door that never locked. Beaumont, Georgia, county seat, population 18,000, give or take whoever left last month. 2 stoplights, a Dollar General on the north end, a courthouse built in 1923 on the south. Railroad tracks cut through the middle of town the way they were drawn to cut, dividing streets, dividing schools, dividing who gets asked for ID at the grocery store and who does not. South of the tracks, on Cypress Street, there is a building that used to be a feed store. The sign above the door reads, Lambert Community Center. The paint is chipped. The basketball hoop out back has a chain net that sings when the ball drops through. Inside, the air smells of peanut butter sandwiches made in bulk and floor wax applied by hand. Aaron Lambert runs this place. He is 34 years old when the story begins. Tall, broad-shouldered, hands roughened by carpentry and constant use. He has no biological children. He is never married. But every afternoon, between 3 and 6, this building fills with children the system has misplaced. Kids between foster placements. Kids whose parents are incarcerated. Kids whose caseworkers stopped returning calls 2 months ago. Aaron teaches them to read at folding tables. He checks their math. He feeds them. When a child falls asleep on the sagging couch in the rec area, Aaron covers them with a quilt his mother made and calls whoever might answer at home. Sometimes no one answers. Those nights, the child sleeps on the couch. Aaron sleeps in the chair beside them. When the county forgets a child, Aaron does not. On his desk there is a framed photograph. 2 small white children hold sparklers against a July 4th sky. Their faces are bright with the kind of trust that has not yet learned to flinch. Aaron never names them. When visitors ask, he says, "Couple kids I looked after once." He changes the subject. A neighbor, an older woman named Ruth, asks him once why he never filed adoption papers for any of the children who stayed. Aaron smiles. "Love doesn't need a stamp from the state," he says. There's no bitterness in it, just certainty. The center serves all races. But Beaumont's power structure, the county commission, the prosecutor's office, the bank board, is uniformly white. Aaron navigates this landscape with politeness and without confrontation. He is liked. He is thanked at church picnics and school board meetings. He is also invisible to power. The men who run Beaumont know his name the way they know the name of the street. It is there, it is useful, and they do not think about it. In 1998, the Beaumont Register runs a short article. The headline reads, "Local man opens doors to children others forgot." The piece mentions that Aaron has personally housed more than a dozen children over 5 years without a cent of state money. The article is clipped and taped to the wall behind the front desk of the center. It yellows. No one takes it down. Aaron's evening routine never changes. After the last child leaves, he sweeps the floor himself. He turns off the lights, one room at a time, the tutoring room, the kitchen, the rec area with the sagging couch. He locks the front door, the one that doesn't quite close right and needs a hip check to latch. Then he walks home, 6 blocks in the dark. The streetlights on Cypress Street work every other pole. For 28 years, Aaron Lambert's name means safety. In 3 days, it will mean something else entirely. 2:14 in the morning, a Wednesday in March. Aaron's phone rings on the nightstand. The voice on the other end belongs to his neighbor, a man named Curtis. Curtis speaks 3 words. "Your center's burning." Aaron pulls on a jacket over his undershirt. He drives 6 blocks in a truck with a cracked windshield, running every stop sign on Cypress Street. By the time he arrives, the east wall has collapsed inward, folding like a closing hand. Volunteer firefighters spray water that turns to steam against the dark sky. The smell is chemical and wrong. Not wood smoke, not old wiring. Something sharper, something that bites the back of the throat. Aaron stands across the street in his unlaced boots, watching the chain net on the basketball hoop glow orange from the heat. He can see the bulletin board through a gap in the north wall, the children's drawings curling, browning, catching. 28 years of thumbtacked artwork. He does not speak. The fire department dispatch log will later confirm the timeline. Call received, 2:14. Engine 3 dispatched, 2:16. On scene, 2:31. Structure 40% involved on arrival. The center will be declared a total loss by dawn. At a press conference the next morning, Fire Chief Tom Brennan reads a prepared statement. His voice is steady for most of it, but at one point, describing the probable origin of the fire, he hesitates. He looks at the page, then down at his shoes. He does not elaborate. He takes no questions. The cameras click. He walks away. No one notices the hesitation. They will. 48 hours after the fire, 2 deputies arrive at Aaron Lambert's house before sunrise. He is standing in his kitchen, holding a coffee mug. The deputies tell him to set it down. He does. They handcuff him at his own table. The mug sits on the counter, still steaming, as they walk him out. The charges: 1 count of arson in the 1st degree, 1 count of insurance fraud. The insurance policy on the Lambert Community Center is valued at $120,000, barely enough to rebuild. Aaron Lambert, a man who spent 28 years feeding other people's children, is accused of burning down his own house to collect a check. He cannot afford an attorney. The court assigns him one. Terrence Hall, public defender, Beaumont County. Hall carries 214 active cases. He meets Aaron once, in a room that smells of disinfectant and stale coffee. The meeting lasts 9 minutes. Hall's caseload spreadsheet, later obtained through a public records request, shows an average client meeting time of 11 minutes. Aaron gets 9. Hall advises Aaron to consider a plea. The system in Beaumont County resolves 89% of felony cases through plea bargains. Defendants who insist on trial face sentencing enhancements. The system is not designed to ask questions. It is designed to process. Aaron refuses the plea. "I didn't burn my own house," he says. Hall shrugs. He has another client in 20 minutes. 8 months later, the trial. 3 days in a courtroom that smells of furniture polish and recycled air. Prosecutor Russell Grady presents the insurance policy, the dollar amount, and a single eyewitness, a neighbor named Carla Davis, who says she saw Aaron near the center at 1:50 a.m. The defense offers almost nothing. Hall calls no expert witnesses. He files no pre-trial motions. He does not challenge the eyewitness identification. He does not request the fire department's full investigative file. The jury deliberates 4 hours. Guilty. 12 years. At sentencing, Aaron Lambert stands straight. His hands are folded in front of him. He thanks Judge Walter Owens for his time. Owens does not look up from the bench. The gavel falls. Aaron Lambert disappears into the Beaumont County Detention Facility. The steel door closes behind him with a sound like a period at the end of a sentence. And for 10 months, no one comes. Russell Grady holds a follow-up press conference. He stands behind a podium with the Beaumont County seal. His tie is knotted tight. His language is precise, practiced, and designed to close a door. The evidence was clear, he says. The jury spoke. The people of Beaumont County can feel safe knowing that no one is above the law. He pauses, adjusts his glasses. Not even those who hide behind community service. Hide behind community service. The phrase lands like a coin dropped on a marble floor. It is deliberate. It reframes Aaron Lambert from a man who gave to a man who took. Grady knows what he is doing. He has done it before. In 19 of his last 22 cases involving low-income defendants, he secured convictions with plea deals or minimal defense opposition. His office calls it efficiency. Others might call it something else. The town absorbs the verdict the way small towns absorb weather. Slowly, unevenly, along lines already drawn. South of the tracks in the neighborhoods Aaron served, people shake their heads. They mutter at gas stations and barber shops. Something isn't right. An older woman who used to drop her grandchildren at the center every afternoon stands in her kitchen and says to no one, "That man wouldn't burn a match if a child was near it." But no one organizes. No one marches. No attorney steps forward. No fund is established. Aaron's name becomes a murmur, and then a silence. North of the tracks, the verdict is accepted with the ease of certainty. A man was tried, the jury decided, the system worked. A few people mention the insurance money and nod as if the number itself, 120,000, explains everything. It does not, but it sounds like it does, and in a small town, that is often enough. The lot where the Lambert Community Center stood sits empty. Yellow caution tape, faded by sun, sags between orange cones. Weeds push through the foundation cracks. Rain collects in the indentation where the front step used to be. On a surviving section of bulletin board, a child's drawing, water-warped, half-burned, is still pinned by a single thumbtack. It shows a house with a big door and stick figures holding hands. No one removes it. No one claims it. Within weeks, a real estate company files a zoning inquiry on the lot. Burke Land Partners, LLC, owned by a man named Harlan Burke, age 61. Burke has been acquiring property along Cypress Street for 14 months, mixed-use development. The center's lot is the last parcel he needs. The timing is noted by one person, Diane Calloway, a 41-year-old investigative journalist at the Beaumont Register, who is working a routine follow-up on the fire. Diane pulls the insurance adjuster's report. It concludes arson. But she notices something. The adjuster's internal email, the one summarizing his findings, was drafted at 8:15 a.m. His site visit did not begin until 2 p.m. that same day. The conclusion was written 6 hours before anyone inspected the ashes. Diane flags this to her editor. The editor reads her notes, nods, and says he'll think about it. He does not run it. The note goes into a file cabinet. Meanwhile, 260 miles northeast in Atlanta, Georgia, a man named Clayton Moore sits in a glass-walled office on the 32nd floor of a building that overlooks Peachtree Street. He is 34 years old, white, private defense attorney. He specializes in appellate work, wrongful convictions, post-conviction relief, the cases other lawyers consider finished. Clayton is eating lunch at his desk. He scrolls the Beaumont Register online. He reads a 3-paragraph brief buried on page 6. Beaumont man sentenced to 12 years for community center arson. The defendant's name is Aaron Lambert. Clayton stops chewing. He sets down his fork. He reads the paragraph again. He reads it a third time. The office noise around him, ringing phones, passing voices, the hum of the building's ventilation, fades to nothing. Clayton Moore has not been to Beaumont in 16 years. He left at 18 on a full academic scholarship that Aaron Lambert helped him earn. Aaron sat with him at the kitchen table for 3 months, drilling vocabulary, timing practice essays with a stopwatch he bought at the hardware store. Clayton studied pre-law at the University of Georgia, graduated top of his class, never looked back. He built a career. He built a reputation. He built a life 260 miles from the man who made it possible. He has not spoken Aaron's name aloud in a decade. He speaks it now, quietly, at his desk, alone. There is something else, a detail the narrator holds for a moment. Harlan Burke, the developer, recently installed a high-end security system at his home outside Beaumont. Cameras, motion sensors, audio recording in every room. A man with that much property, Burke tells his neighbors, can't be too careful. The detail seems irrelevant. It is anything but. Clayton Moore books a flight to Beaumont. He packs one suit. He does not tell his firm why. Clayton Moore drives a rental car down streets he memorized as a child. The roads are narrower than he remembers. The pecan trees along Cypress Street are taller. The Dollar General is new. The courthouse is not. He parks in the same lot where Aaron used to park the truck with the cracked windshield. The same lot where Clayton once sat in the passenger seat, eating a gas station sandwich while Aaron ran inside to pay a water bill. He walks into the Beaumont County Courthouse wearing a charcoal suit and polished shoes. His briefcase is leather, monogrammed. The security guard nods him through. The clerk at the filing window looks up. "You from Atlanta?" she asks. Clayton says yes. She asks who he is representing. He says, "Aaron Lambert." The clerk pauses. Her fingers hover over the keyboard. She glances at him. A quick look, the kind that measures something without meaning to. Then she types. Clayton files an emergency appeal citing ineffective assistance of counsel and newly discovered evidence. The case number is 2024-CV-03182, Beaumont County Circuit Court. The filing is stamped, docketed, entered into the system. It generates an automatic notification to the prosecutor's office. For the first time in 10 months, Aaron Lambert's case has a pulse. Russell Grady learns about the filing the same afternoon. His assistant places the document on his desk. "Private attorney out of Atlanta," she says. "Name's Clayton Moore?" Grady scans the motion. The language is tight. Brady violations, suppressed evidence, constitutional deficiencies. This is not a form filing. This is a weapon. Grady picks up his phone and dials the county attorney's office. He does not recognize Clayton's name. He should. In the original trial, Aaron's public defender sat slumped. His files were loose, some dog-eared, some clearly belonging to other cases. His tie was loosened before the first witness was called. Clayton Moore sits differently. His files are tabbed with colored dividers. His pen is capped until he needs it. He makes eye contact with the courtroom staff. The difference is visible, not in style but in intent. This attorney came to fight, and something else is happening at the same time in the same building. Eleanor Shaw, 36, recently appointed to the Beaumont Circuit Court bench, reviews her new docket in chambers. She is white, sharp-featured, known for reading every filing before the attorneys arrive. She turns a page and sees the case. She sees the name. Aaron Lambert. Her hand stops. She reads the name twice. She closes the file and sets it on her desk. She sits very still for a long time. The clock on the wall ticks. She does not move. The narrator does not yet explain why. 6 weeks ago, Aaron Lambert was a convict without a voice. An overloaded public defender met him for 9 minutes and called it representation. A prosecutor called him a fraud, and the county believed it. No one filed a motion. No one asked a question. No one came. Now a private attorney from Atlanta has entered the case with a briefcase full of tabbed files and a motion that uses words like Brady violation and newly discovered evidence. And a judge is holding a file she cannot put down. He files the appeal. 4 words. The system notices. Clayton needs evidence. For that, he needs someone who already knows where Beaumont buries its mistakes. He finds Diane Calloway at a corner booth in a diner on 3rd Street. She is drinking black coffee and reading a public records response on her laptop. one of 9 she has filed in the past 3 months, none of which have produced a published story. Her editor has killed every one. Clayton introduces himself. He tells her he is representing Aaron Lambert on appeal. Diane sets down her coffee cup. "I've been waiting for someone to say that name in a courtroom," she says. They begin. The first thread Diane pulls is the fire investigation itself. Under Georgia's Open Records Act, she requests the complete fire department case file, not the summary released to the press, but the full investigative report. The request takes 11 days. The county records office responds with a partially redacted file and a cover letter citing ongoing investigative privilege. Diane files a second request, citing the case's closed status. On the 14th day, the full file arrives. It is 43 pages long. The summary released to the public was 4. The full report was written by Glenn Crawford, a fire investigator with 22 years of service. Crawford examined the site for 3 days. He photographed the burn patterns. He took soil samples from the northeast corner of the foundation. He documented pore patterns in the concrete, irregular branching, the signature of a liquid accelerant spread by hand. His conclusion is on page 31. It reads, "Origin consistent with accelerant introduced externally at the northeast corner of the structure, not consistent with electrical fault, occupant activity, or self-ignition." Glenn Crawford determined, within 72 hours of the fire, that someone poured an accelerant against the outside wall of the Lambert Community Center and lit it. The fire was not set from inside. It was not set by Aaron Lambert. It was arson committed against him, not by him. This report was submitted to the Beaumont County Prosecutor's Office on the Thursday following the fire. It was received, date-stamped, and filed. It was never entered into evidence at trial. It was never provided to the defense. It was never mentioned in Grady's opening or closing statements. Glenn Crawford was reassigned to administrative duties 3 weeks after submitting it. He now processes building permits at a desk near the back of the fire station. No one has asked him about the report since the day he filed it. Clayton reads the report 3 times. He marks page 31 with a yellow tab. Then he picks up the phone. The second thread is the insurance adjuster. Clayton subpoenas the adjuster's mobile phone records through a discovery motion. The GPS metadata tells a story the adjuster's written report does not. On the morning of the site visit, the adjuster's phone pings at 8:03 a.m. Not at the fire scene, not at the insurance company's regional office, but at the business address of Burke Land Partners, LLC, Harlan Burke's company. The adjuster spent 90 minutes at the developer's office before conducting his independent inspection. His conclusion, arson by the policyholder, was drafted before he ever touched the ashes. The third thread is money. Diane works late. She pulls financial disclosure filings available through the Georgia Secretary of State's office. She cross-references corporate registrations, annual reports, and wire transfer records obtained through Clayton's discovery motions. The pattern emerges on the third night. 3 wire transfers from Burke Land Partners, LLC to a company called Ridgeline Services. Each transfer, $8,500. 3 payments over 6 weeks, structured below the $10,000 federal reporting threshold, the point at which banks are required to file currency transaction reports. Someone understood the rules well enough to stay beneath them. Ridgeline Services is registered to a single agent in an adjacent county, a man with 2 prior arson convictions in Telfair and Dodge counties. His name does not appear in any public record connected to Aaron's case. He is referred to in court filings only as the Ridgeline Contractor. The shell company has no employees, no office, no website. Its registered address is a mailbox at a shipping store off Interstate 16. 3 payments, 3 amounts designed to avoid detection. 1 shell company tied to a convicted arsonist. The math is not complicated. Burke paid someone to burn the center. The adjuster coordinated with Burke before writing his report. Grady buried the fire investigator's findings that would have revealed the entire scheme. 3 actors, 1 land deal, One man sitting in a cell for a crime committed against him. The fourth thread is the eyewitness. Clayton drives to the home of Carla Davis on a Saturday afternoon. Carla lives 4 houses down from where the center stood. She was the prosecution's only eyewitness, the person whose testimony placed Aaron near the center at 1:50 a.m. on the night of the fire. Carla opens her front door halfway. She does not invite Clayton inside. She is nervous. Her hands grip the door frame. Behind her, a television is playing. She lowers the volume with a remote but does not turn it off. Clayton does not press her. He introduces himself. He explains the appeal. Then he asks one question. Did you see Aaron Lambert at the center that night? Carla is quiet for 12 seconds. Her eyes move to the street behind Clayton, then back. Then she says, I saw someone. I'm not sure it was Aaron. It was dark. I was looking through my bedroom window. I told them that. Clayton asks who them is. Carla says Grady's investigator came to her house the morning after the fire. He sat in her living room. He told her, just confirm what we already know. You don't want trouble. He did not explain what trouble meant. He did not need to. She signs a recantation affidavit at her kitchen table. Her hand shakes as she writes her name. She asks Clayton if she will get in trouble for signing it. He tells her the truth. He does not know. And now the narrator pauses, because there is something Clayton has not told Diane. Something about Judge Eleanor Shaw. Eleanor Shaw's maiden name is Moore. She is Clayton's sister. Before she was Judge Shaw, before she was Eleanor Moore, she was one of the 2 children in that photograph on Aaron Lambert's desk. The girl holding the sparkler with both hands. 8 years old, standing on a porch in Beaumont, Georgia on a July night beside a man who had opened his door to her 3 hours earlier and never closed it. Aaron Lambert raised Clayton and Eleanor after their mother left them on his doorstep 28 years ago. He fed them. He helped them with homework at folding tables. He drove Eleanor to her first day of high school in the truck with the cracked windshield. He paid for Clayton's SAT prep out of his own pocket, money the center could not spare. He never asked for credit. He never filed a single piece of paperwork claiming them as his own. And now one of those children is building the case. The other is assigned to hear it. If you've ever watched someone get buried by a system that was supposed to protect them, drop a word in the comments. One word. We'll know what it means. The evidence is assembling. But Russell Grady is not a man who loses quietly, and he has just learned who Judge Eleanor Shaw really is. Grady moves fast. Within 24 hours of learning Eleanor Shaw's connection to Aaron Lambert, he files a motion to disqualify her from the case. The motion cites undisclosed personal relationship with the defendant and demands immediate reassignment to another circuit. The docket entry is time-stamped 11:43 p.m., filed late at night, which tells Clayton everything he needs to know. This is not procedure. This is panic. But panic with power is still dangerous. If Eleanor is removed, the case transfers to a different judge, one who may be less willing to hear an appeal that threatens the county's most powerful prosecutor. One who may be more inclined to bury what Grady has already buried once. Clayton reads the motion in his hotel room. He sets his jaw. He begins drafting his opposition brief. Meanwhile, Diane Calloway finishes her investigation. 3,000 words, every receipt documented, every timeline cross-referenced. She submits the piece to her editor, Gerald Thornton, on a Tuesday morning. She attaches a legal review she commissioned herself, paid out of pocket, confirming that every claim in the article is supported by documented evidence. Thornton reads it in his office with the door closed. He reads it twice. He calls Diane in at noon. He does not sit down. Neither does she. His desk is clean except for her article, printed out, and a yellow legal pad with 2 lines of notes. Burke's group is responsible for approximately 40% of our print advertising revenue, he says. He does not make eye contact. I need you to hold this piece until I've consulted with our publisher. The translation is simple. Kill the story. Diane stares at him. She does not argue. She has been a journalist for 19 years. She knows what a killed story sounds like. She picks up her laptop from his desk. She walks out of the office. She does not close the door behind her. She sits in her car in the parking lot for 4 minutes, engine off, hands on the steering wheel. Then she picks up her phone and calls Clayton. The newsroom email, Thornton to Diane, sent 1 hour later to formalize the conversation, will eventually become part of the public record. Its language is careful, bureaucratic, and empty. But not yet. In the Beaumont County Detention Facility, Aaron Lambert collapses during evening count. It is a diabetic episode. Aaron has been managing type 2 diabetes for 11 years, a condition stable enough on the outside where he controlled it with medication and a careful diet. In the detention facility, he has no control over either. The meals are processed, starch-heavy, served on a schedule designed for logistics, not health. He has submitted 3 medical request forms in the past 2 weeks, each one handwritten on lined paper, each one asking for an adjustment to his insulin dosage. The forms sit in an intake basket at the infirmary, unprocessed. A corrections officer finds them during a later review. All 3, still paper-clipped together, untouched. Aaron's cellmate, a 29-year-old named Nathan Perry, calls for a guard. The guard arrives 9 minutes later. Aaron is taken to the infirmary on a stretcher. He is denied transfer to an outside medical facility for 9 hours. When the facility nurse finally adjusts his medication, his blood sugar has been dangerously low for most of the night. Nathan Perry will later provide a written statement describing the delay. He writes in block letters on lined paper, "I called for help at 8:41 p.m. Nobody came until 8:50. He was on the floor the whole time." Through his office, Russell Grady issues a public statement regarding the appeal. It reads, in part, "The Beaumont County Prosecutor's Office stands by the integrity of the conviction and trusts that the appellate process will confirm what the jury already determined." The statement is 4 sentences long. It acknowledges nothing. It concedes nothing. It is the language of a man who believes the walls he has built will hold. Aaron Lambert is running out of time. His body is failing him in a facility that processes medical requests the way it processes justice, slowly, indifferently, on its own schedule. His case is under legal siege, and the one person who might save him from the bench, his foster daughter, may be pulled from the courtroom before she hears a single word of evidence. Clayton sits in his hotel room in Beaumont. The opposition brief is finished. The evidence binder is 3 inches thick, but none of it matters if the judge is removed, if the story stays buried, if the system does what it has always done. Process, close, forget. His phone rings. It is not Diane. It is not Eleanor. It is a collect call from the Beaumont County Detention Facility. The automated voice says, "This call is from an inmate at the Beaumont County Detention Facility. This call may be monitored and recorded." Then Aaron's voice, tired, not broken, tired, the way a load-bearing wall sounds when it has held weight for too long. He does not complain about the medical neglect. He does not ask about the motion to disqualify. He does not ask about the evidence. He says, "I need you to stop, son." Clayton does not respond. "I've had my time," Aaron continues. "I raised who I raised. I did what I could. I don't want you to burn your life for mine." Clayton holds the phone against his ear. 6 seconds of silence. The line hums, a thin electrical sound, the same frequency as the fluorescent tube in the courtroom. Then he speaks. "You didn't let me burn when I was 8 years old. I'm not letting you burn now." Aaron is quiet. The line holds. 28 years ago, a Tuesday evening in October. The air smells of wet leaves and cooling asphalt. A woman in a stained denim jacket stands at Aaron Lambert's screen door. She holds a boy's hand in her right and a girl's hand in her left. The boy is 6. He's wearing a t-shirt 2 sizes too large. The girl is 8. Her sneakers do not match. The woman says 4 words. "I can't do this anymore." She releases their hands. She walks down the porch steps and across the street to a car idling at the curb. She does not look back. The car pulls away. Aaron kneels. He is eye level with the boy. He smells like sawdust and dish soap. "You hungry?" he asks. The boy nods. The girl says nothing. She holds her brother's hand tighter. Her knuckles are white. She is looking past Aaron into the house as if measuring whether it is safe. She has learned to measure rooms before she enters them. Aaron opens the screen door. It doesn't lock. It is never locked. "Come on in," he says. Nothing more, no promises, no explanations, just a door and a man standing beside it. 3 years pass in the space between breaths. Aaron teaching the boy to ride a bicycle in the parking lot behind the center. The boy's knees are skinned, and Aaron puts the Band-Aids on himself, pressing each one carefully, blowing on the scraped skin the way his own mother once did. The girl doing homework at the folding table every night. Aaron sits beside her, checking her math, never raising his voice when she gets it wrong, never leaving until she gets it right. The 3 of them on the front porch on July 4th holding sparklers. The photograph is taken by Ruth, the neighbor. No one asks for a copy. Aaron frames it anyway. Back to the present. The collect call. Aaron has hung up. Clayton stands in his hotel room, the phone still pressed to his ear. The dial tone plays, a single, flat note that fills the room like a held breath. This is the lowest point. The man who saved everyone is asking to be forgotten. The children he raised are being told to walk away. The system that convicted him does not know his name. The system that jailed him loses his medical forms. Clayton sets the phone on the nightstand. He opens his laptop. The opposition brief glows on the screen. Still here? Good, because what comes next is why this story exists. He does not sleep. The appellate court rules on Grady's motion to disqualify Judge Eleanor Shaw. The ruling arrives on a Thursday morning, 6 pages long, single-spaced. The finding is precise. No legal or biological parental relationship exists between Judge Shaw and the defendant. No formal adoption, guardianship, or custodial order was ever filed with any court of record in the state of Georgia. The court finds no statutory basis for disqualification under OCGA Section 15-1-8. Motion denied. The irony is quiet and sharp. Aaron Lambert never filed adoption papers. "Love doesn't need a stamp from the state," he once said, smiling, without bitterness. That absence of paperwork, the informality that denied Eleanor a legal father for 28 years, now keeps her on the bench. The system's own formalism saves what the system tried to destroy. Diane Calloway does not wait for the Beaumont Register. She publishes her 3,000-word investigation on an independent journalism platform that same weekend. The headline: Beaumont prosecutor buried fire report that cleared defendant. Developer had financial motive. She names no one who has not already been named in court filings. She cites every receipt by document number. The piece is rigorous, measured, and devastating. Within 48 hours, regional outlets pick up the story, then national ones. Comment sections fill with a single question, repeated in different words by different people. How did this happen? Then the phone calls start. Clayton's office in Atlanta, where a paralegal has been fielding routine messages, begins receiving calls from across Georgia, Alabama, and Florida. The callers are adults now: teachers, mechanics, nurses, a firefighter in Savannah, an accountant in Mobile. They all say the same thing in different ways. Aaron Lambert took care of me. What can I do? 11 of them drive to Beaumont. They do not organize through social media. They call each other directly. Numbers saved in phones for years, never deleted, rarely used. They arrive over the course of 2 days. They find each other in the parking lot of the courthouse. And the morning before the hearing, they stand on the courthouse steps. They do not carry signs. They do not chant. They stand. Some hold photographs of themselves as children, gap-toothed, squinting in summer light, standing in front of the Lambert Community Center. One holds the newspaper clipping from 1998. In Beaumont's white church on Cedar Avenue, a pastor, not named, described only by what he says, mentions Aaron Lambert in his Sunday sermon. "We owe debts we haven't acknowledged," he says. The congregation is quiet. Clayton visits Aaron in the detention facility. He carries a single sheet of paper, a list of names, former foster children willing to testify to Aaron's character. 11 names. Aaron takes the paper. He reads each name slowly, his index finger tracing the letters. He does not speak. He folds the paper once and holds it against his chest. The hearing is in 3 days. Clayton has the evidence, the witnesses, and the law. But Russell Grady still has one advantage. He doesn't know about the phone call. Clayton returns to the financial trail. Burke's LLC payments to Ridgeline Services establish motive and method, but they do not connect the prosecutor directly to the conspiracy. Grady can claim ignorance. He buried the fire report, yes, but perhaps he was merely negligent, not complicit. Perhaps he simply trusted the wrong adjuster. Perhaps the system failed and Grady was just another cog. Clayton needs the link. He finds it where Harlan Burke left it, in Burke's own house. The high-end security system, cameras in every room, audio recording on a continuous loop backed up to a cloud server managed by a private security firm. Burke installed it 14 months ago when he began acquiring property along Cypress Street. A man with that much property, he told his neighbors, can't be too careful. Clayton's subpoena reaches the security company on a Monday. The compliance officer reviews the request, confirms the court order, and releases the audio logs for the relevant time period. The file arrives as a digital archive. Hundreds of hours of ambient sound, phone calls, television noise, footsteps, and silence. The timestamps are precise to the second. Clayton's paralegal isolates the phone calls. There are 63 outgoing calls and 41 incoming calls within the relevant window. She listens to each one, taking notes in a spreadsheet. Caller, recipient, duration, content summary. Most are mundane. Contractor scheduling, permit inquiries, calls to Burke's wife about dinner plans. On the third day of review, at 11:15 p.m., she finds it. A call between Harlan Burke and Russell Grady, time-stamped 13 days before the fire. 2:32 p.m. Duration, 4 minutes and 18 seconds. Burke speaks first. His voice is casual, familiar. Two men who have spoken before, many times, about many things. There is no greeting. They begin mid-thought, the way people do when a conversation is a continuation, not a beginning. Once that lot is cleared, Burke says, we move on the rezoning. I've got the permits drafted already, Grady responds. His voice is unmistakable. The same measured cadence from the press conferences, the same careful diction. I'll handle the rest, he says. Just keep it clean on your end. What about Lambert? Lambert won't be a problem. 13 days later, the Lambert Community Center burns to the ground. 14 days later, Aaron Lambert is arrested in his kitchen. This is not a recording of a man who ignored the truth. This is a recording of a man who helped design the lie. Russell Grady did not merely suppress the fire investigator's report. He knew what the report would say before the fire was set. He knew because he was part of the plan. Clayton listens to the recording 3 times. He sits at the desk in his hotel room, headphones on, eyes closed. The 3rd time through, he stops at one phrase. Lambert won't be a problem. He plays it again. Grady's voice is flat, administrative, the tone of a man discussing a line item on a budget, not a human being whose life is about to be destroyed. Clayton notes the timestamps. He prepares a chain of custody declaration from the security company, digitally signed, server verified, tamper-evident. The compliance officer signs an affidavit confirming the archive was not accessed, modified, or transferred between the date of recording and the date of release. Clayton files the recording as newly discovered evidence under Georgia Code Section 5-5-23. The filing is sealed until the hearing to prevent Grady from constructing a counter-narrative. Clayton sits in his hotel room. The laptop screen glows. The timestamp blinks, 14:32:09. Outside Beaumont is quiet. The streetlights on Cypress Street work every other pole, the same as they always have. Tomorrow morning, courtroom B, the Honorable Eleanor Shaw presiding, and Russell Grady will hear his own voice played back to him. 9 in the morning, courtroom B, Beaumont County Courthouse. The same room where Aaron Lambert was convicted 10 months ago. Same wood-paneled walls, same fluorescent hum, same scarred table. Different energy. The gallery is full. 11 former foster children sit in the first 2 rows. Their clothes are clean, their faces composed. Diane Calloway sits in the press section, laptop open, fingers ready. Grady sits at the prosecution table. His posture is straight, his pen is uncapped. He does not know what is coming. Aaron is brought in through the side door. Orange jumpsuit, shackled at the wrists. He sits at the defense table beside Clayton. He does not look at the gallery. He looks at the table. Clayton rises. He presents the evidence in order, each piece building on the last. The suppressed fire investigation report by Glenn Crawford. The conclusion that the fire was set from outside, not inside. Grady objects. Overruled. Carla Davis's signed recantation affidavit. Her original testimony was coerced by Grady's own investigator. Grady objects. Overruled. The insurance adjuster's GPS metadata, his phone at Burke's office 90 minutes before the site visit. Grady objects. Overruled. Burke's LLC bank records. 3 payments of $8,500 to a shell company linked to a convicted arsonist. Grady objects. Overruled. Then Clayton asks the court's permission to play a recording. Granted. Grady's voice fills the courtroom. I'll handle the rest. A pause. Lambert won't be a problem. The courtroom is silent. Grady stares at the table. His pen is still. His co-counsel does not move. Someone in the gallery inhales. No one exhales. Grady's attorney requests a recess. Eleanor denies it. Grady states, through counsel, that the recording is taken out of context and has not been properly authenticated. Eleanor notes the objection for the record. The chain of custody declaration, digitally signed by the security company, is entered as an exhibit. Objection overruled. Eleanor reviews the evidence from the bench. She speaks slowly. Each word lands with the weight of a gavel that has not yet fallen. The court finds that material exculpatory evidence was withheld from the defense in violation of Brady v. Maryland. The court further finds that newly discovered evidence constitutes grounds for immediate vacatur of the conviction. Then she stops. She removes her reading glasses. She sets them on the bench. Before I read the final disposition, she says, I need the record to reflect something this court considers relevant to the character of the defendant. She looks at Aaron. This man took me into his home when I was 8 years old. He fed me. He clothed me. He educated me. He loved me without condition and without compensation. He is my father in every way that matters. The record should know who it is setting free. Clayton stands. His voice is steady, but only just. Your Honor, he's my father too. Dead silence. The fluorescent hum stops, or perhaps it doesn't, but no one can hear it anymore. A pen rolls off the prosecution table and hits the floor. No one picks it up. Aaron Lambert, shackled at the wrists, lowers his head. His shoulders shake. He does not make a sound. Conviction vacated. The defendant is ordered released immediately. This court refers the matter to the Georgia Attorney General's office for investigation of prosecutorial misconduct. The gavel falls. It sounds like a door opening. The shackles are removed in a side room. Playton brings clothes, a blue button-down shirt, khaki pants, shoes that fit. Aaron dresses slowly. His hands are steady. He walks through the courthouse hallway. The fluorescent hum is behind him now. He pushes open the front door and steps into afternoon sunlight. The warmth lands on his face like a hand he hasn't felt in 10 months. The 11 former foster children line the courthouse steps. Teachers, mechanics, nurses, a firefighter. They do not cheer. They do not applaud. They stand. Some cry quietly. Aaron walks down the steps. He stops at each one. He knows every name. In the weeks that follow, Russell Grady is suspended pending a state investigation. Harlan Burke is indicted on conspiracy charges. Glenn Crawford, the fire investigator, is reinstated to active duty. The Beaumont Register runs Diane Calloway's investigation on the front page, above the fold. The community center lot on Cypress Street is deeded to a nonprofit in Aaron Lambert's name. 28 years ago, a screen door that never locked swung open for 2 children who had nowhere else to go. Today, a courthouse door swings open for the man who never turned anyone away. If this story moved you, if you know what it means to fight for someone who once fought for you, share it, subscribe, and leave a comment. Who is your Aaron Lambert? Some doors don't need locks. They just need someone willing to open them.
You know what stayed with me? It's not the evidence. It's not the phone call that brought Brady down. It's that collect call. Aaron Lambert, psycho, sick, forgotten, picks up a phone and tells his son to stop fighting for him. I don't want you to burn your life for mine. That's who this man is. Aaron never had a birth certificate with his name on anyone's father's life. No court order, no custody paper, no proof. All he had was a screen door that didn't lock, and the choice to open it every single time. 28 years later, that child walked into a courtroom in a T-shirt and said that into the record. No paperwork made that family loved it, and no system could undo it, even it tried. I think most of us know an Aaron Lambert, someone who showed up when no one else did, someone who gave what they couldn't afford to give. Maybe they raised you, maybe they fed you, maybe they just stayed when staying was the hardest thing to do. And maybe you never told them what that means. So, if someone comes to mind right now, one person who opened the door for you when the world didn't, leave their full name in comment. Just a name. They probably never see it, but you will remember you said it. Subscribe, share this. Because stories like Aaron's don't tell themselves. Some doors don't need locks. They need to someone willing to open them.